Namaste, welcome. Welcome all of you to this fourth virtual international summer school organized by Nivaaran. Good morning to all the guests who are from the Pacific and elsewhere, from Caribbean. Good afternoon and good evening to all. In this welcome address at the summer school, fourth summer international summer school, I first of all express my gratitude to SIMC, Singapore International Mediation Center, and Commonwealth Lawyers Association, who have been collaborators with us. Though George Lim and Brian Speers, our today's speaker, has been there to help us in this running of Nivaaran school, summer school by Nivaaran. But this year, we have persuaded CLASC, SIMC to be in collaboration. Nivaaran has been inactive in organizing these summer schools. And this is the fourth one. Since 1920, we have been organizing this summer school and promoting the mediation. Mediation promotion is a process which you will see, during the course of this summer school, you will realize that how mediation process is important in dispute resolution. Our guest today is Brian Speers. Brian Speers is a seasoned mediator and who has been mediating for over more than a decade. His expertise in mediation field is well known because he has been participating in international mediation as well as domestic mediation at his native place in Northern Ireland, England, and Wales. Brian Speers has been a former president of Commonwealth Lawyers Association. So his contribution to this mediation process is tremendous. Our today's topic is the historical perspective of dispute resolution, development of legal system and culture. In fact, ever since the civilization starting growing, there are difference in opinion. And in fact, difference of opinion is the beginning of growth. When there is a difference grows, a different point of view comes. But as the civilizations grew, the difference of opinion culminated into disputes. And whenever there are disputes, there has to be a resolution mechanism. The resolution mechanisms developed firstly as the might of the power, who is the powerful, we came to know as the Jungle Raj. And then came an adjudicatory process, where a systematic adjudication was there. In all cultures throughout the world, in different parts of the country, different parts of the world, resolving dispute amongst others, amongst the people, by way of peer pressure or by way of some people coming up, the wiser people, coming up and resolving the dispute without adjudicating, has been prevalent throughout the world. In fact, the dispute resolution through peaceful process is a culmination which has been now once again developed as a peace jurisprudence. Because in adjudication process, there is always some sort of resentment or not acceptance. Resolving disputes through peaceful process. You will today hear Brian Speers And before I welcome him, before I give the floor to him, I'll just refer to written documents or instances which is prevalent in Indian subcontinent. The one is Lord Buddha, when he helped two kingdoms, Shakyas and Kallavis. They were fighting over a dispute of water distribution of river Rohini. And he helped in resolving that dispute. And that you find that recording in the UN office in New York, because UN is now a pioneer institution in resolving a dispute. The second, which we consider it as a recorded document, that's a 16th century document, where a great poet Tulsidas helped resolving a dispute between two members of a family. And there is a written document. This written document is available in the High Court Museum of High Court of Allahabad. So these are the two authentic incidents. So before I enter into further, I invite Brian Speers to address you on the topic, today's topic. Brian, all yours.
Thank you, Jitendra, and it's a great pleasure to be here among so many friends. This is not my first time participating in the excellent Nivaaran summer school, and I very much admire the work that has gone on behind the scenes to pull this together. And of course, I thank my dear friend Santan for all of his work. And it's great to see you through the Zoom screen today again, Santan. Can I commend to all of you the work that Nivaaran has done, and can I also express pleasure in the joint arrangement that has been made with the Singapore International Mediation Centre and the Commonwealth Lawyers Association, and I acknowledge the current president, Peter Maynard, who took part yesterday in the opening ceremony. During my time as president of the CLA, it was a tremendous opportunity to engage with mediators across the Commonwealth. And I have found, as I believe many of you will find and have found, that mediators make the greatest of company. They are reasonable people. They have an interest in the views of others. They have learned to be patient and attentive, and it's great to be in the company of mediators. Now, I am normally based in Belfast and would have put on a tie to address such a noble gathering, but you find me on holiday in the south of Spain, and so please excuse the relative informality of my appearance today. This talk, actually, I'm really glad that Jitendra gave some historical perspective, because my perspective will really be based on the evolution of mediation within the legal system, primarily from a UK perspective, but I think with a tremendous lesson leading into a big debate that is relevant today in India and elsewhere. And that is the issue of whether or not mediation should be mandatory and people should be obliged to participate in mediation rather than simply encouraged. And I hope that by dipping into some of the jurisprudence over the last 30 years or so in the UK, we will come to the point where the relevance of the journey of embedding mediation in the civil justice system will be clear. Let me, first of all, say that my personal involvement in mediation goes back almost exactly 30 years, where our law society arranged a simple talk. And by then I had been practicing litigation and was thoroughly fed up with the litigation process. So many documents to prepare in a particular way, to be filed in a particular time slot. The emphasis seemed to be on process and not on the merits or interests of the parties. And when we got to court, there were frequently adjournments and delays, and it was thoroughly unsatisfactory. Was there not a better way of dealing with what is quite ordinary, the ordinariness of people having a dispute? And I was then selected to go to a conflict resolution program in New York. And that really opened my eyes to the thinking from an American perspective, where mediation had been embedded in the court system for, I suppose, maybe 15 or 20 years by the mid-90s. And the history of mediation within the court process, formalized with court practice directions and protocols, has really taken off since the mid-90s in the UK, but it was already by the mid-90s established in the States and also in Australia. But again, that maybe relates back to more or less the mid-1980s or so. Having taken part in that course, which is approximately 30 years ago, I've then followed mediation and its developments very closely in the civil justice system within the UK and in my own jurisdiction of Northern Ireland. And while it is right that for me and for the purpose of this short talk, the historical perspective is over the last 30 years, as Jitendra has pointed out, mediation is as old as the hills. In many societies, people with grievances and disputes have turned to their elders and their wise people to resolve issues. People will be familiar with the quotation from Abraham Lincoln, a lawyer, who said, "Discourage litigation. Persuade your neighbors to compromise whenever they can. Point out to them how the nominal winner is often a real loser in fees, expense, and waste of time. As a peacemaker, the lawyer has a superior opportunity of being a good man. There will be business enough." So while it is absolutely the case that mediation did not begin 30 or 40 years ago, nevertheless, in the last 30 years, mediation has become an integrated part of the civil justice system in many jurisdictions. And let me focus for a short time on the UK. Can I start by considering 2 or 3 cases around the early 2000s? In one such case, Dunnett against Railtrack, decided on the 18th of April 2002. This involved Mrs. Dunnett's horses straying onto a section of railway line and being killed by a train, and she sued Railtrack for failing to adequately fence off their rail track. The company had a strong legal defense and won their case, and ordinarily would have been awarded costs. However, the court decided not to award them costs, but to penalize them in that way because they had in the court's view, unreasonably refused to take part in an ADR or mediation process. The judge said, "It is hoped that any publicity given to this part of the judgment will draw the attention of lawyers to the possibility that if they turn down the chance of ADR, they may have to face uncomfortable consequences." Later in 2002, in fact, in June, a claim was brought by a Mr. Frank Cowell, a resident of an old people's home that was going to be closed down by Plymouth City Council. It was his home. It was convenient for visits by his family. He applied for a judicial review of that decision by the council. And the court said that even in disputes between public authorities and members of the public for whom they are responsible, insufficient attention is paid to the paramount importance of avoiding litigation whenever this is possible. Both sides must by now be acutely conscious of the contribution mediation can make to resolving disputes in a manner with which both meets the needs of the parties and the public and saves time, expense, and stress. The judge went on to say, which is a big lesson for mediators, "It is indeed unfortunate that instead of the parties focusing on the future, they insisted on arguing about what had occurred in the past. The parties should have been able to come to a sensible conclusion as to how to dispose the issues which divided them. If they could not do this without help, then an independent mediator should have been recruited to assist. Today," and this was in 2002, "sufficient should be known about mediation to make the failure to adopt it, in particular where public money is involved, quite indefensible." So that was interesting endorsement of mediation 21 years ago. And in another case involving a solicitor suing the solicitor who advised him in connection with a partnership dispute, the case of Hurst against Leeming, and the court referenced both the Dunnett case and the Cowell case and concluded in this lawyers in dispute with each other matter that ADR is at the heart of today's civil justice system. And if any unjustified failure to give proper attention to the opportunities afforded by mediation, there must be anticipated that adverse consequences will arise. Now, not everybody in the UK agreed with that direction of travel. And in one judgment in 2003, Lorenzo against Burden, the judge said, "It is possible that a failure to engage in mediation may have adverse consequences for a successful party. It is not by any means inevitable. A party can quite properly discharge his obligations to consider ADR and to attempt to engage in it if he takes a view there are other forms of ADR more appropriate, so long as parties are showing a genuine and constructive willingness to resolve issues. It does not seem to me that a party will be penalized because they have not gone along with the ADR process suggested by the other side." So quite a contrast in views in the early part of the 2000s. And these views were resolved in the seminal case in 2004 of Halsey against the Plymouth General Health Trust, the Milton Keynes General Health Trust in 2004. I will provide all the citations to these cases, but they are very easily findable, and particularly if you just note Halsey against Milton Keynes General Health Trust 2004. Here, Mrs. Halsey was suing the Health Trust, alleging medical negligence because her husband died in receipt of medical attention. She requested mediation on multiple occasions. The Health Trust refused, believing that they had a strong case, and the question was whether or not their refusal was reasonable. Lord Dyson gave the leading judgment of the Court of Appeal, and he said that mediation was to be encouraged, but it should not and could not be made compulsory. He said the encouragement could be robust, and they set out a number of circumstances where it might be reasonable to refuse mediation when offered, and these include such concepts which have since been much litigated over as the nature of the dispute, the costs of mediation, delay in organizing mediation, the merits of the case, and whether a mediation would have a reasonable prospect of success. Lord Dyson was concerned that making mediation compulsory would deny people their right to a hearing and a trial. And after that case, many cases followed the Halsey judgment, and there were numerous adverse cost orders made as a result of Halsey, based upon people being found to have unreasonably refused to mediate. There was also some challenge to his view that by making mediation compulsory, somehow you were denying people their right to a trial. And in 2014, at the first Commonwealth Lawyers Mediation Conference in Belfast, and some who are on this meeting were present at that conference, Lord Dyson gave a judgment, a paper 10 years on from his judgment in Halsey. And I have that paper here. He acknowledges that Halsey was a controversial judgment. And he said right at the outset of his important talk that he believes that Halsey was correctly decided. He said there were three main propositions with which he still agreed. First, that mediation is important and should be used in many cases, but it is not a universal panacea. Second, he said, parties should not be compelled to mediate. And thirdly, he said, adverse costs orders are an appropriate means of encouraging parties to use mediation. Now, I wanted to say also that he recognized that as a result of a case in Europe called Alabi, that actually requiring mediation before accessing the courts, he accepted was not, in fact, a denial of the party's right to a hearing. And he said that so long as certain conditions were in place, he could see that requiring mediation may not interfere with the right to a trial. That was the view in 2014. In 2022, in June last year, at the second Commonwealth Mediation Conference in Belfast, Sir Geoffrey Voss, the Master of the Rolls in England and Wales, noted that in July of 2021, the Civil Mediation Council had come out in favour of the appropriateness in many cases of compelling mediation. And Sir Geoffrey Voss spoke about the integration of many dispute resolution opportunities within the civil justice system. he said the focus should not be on dispute in alternative dispute resolution, but should be on resolution. And he saw how the integration of litigation with arbitration and mediation would bring about a new and compelling access to civil justice. So, although I have jumped from Halsey in 2004 to Sir Geoffrey in 2022, you should note that over the years, there have been many cases dealing, for example, with does mediation have a reasonable prospect of success? Is silence the equivalent of a refusal to mediate? Can a mediator be compelled to give evidence? And what is the extent, if any, of mediation privilege? These are all cases that show how integrating mediation within civil justice in a mature justice system throws up questions and challenges, and not all jurisdictions in the Commonwealth, of course, are mature mediation systems of civil justice. The issue of compulsory mediation being now considered actively in the UK, and indeed by active I mean as recently as the end of June this year, there's a case which I need to mention, which is the case of Churchill against Merthyr Tydfil Council. Now, I must say I find some of these cases, their facts are intriguing, because this one involved the invasive species known as Japanese knotweed. Very difficult to eradicate, and poor Mr. Churchill found that his garden had been infested with Japanese knotweed, which he maintained had come from council-owned property, and that they had failed to abate what was an obvious potential nuisance to him as a neighbour. The council said that bringing the matter to court was disproportionately expensive whenever they had a perfectly reasonable dispute or complaints mechanism available. And the issue has now been referred to the Court of Appeal in England for hearing, I think, sometime very soon. And permission was granted on the 27th of June, less than 1 month ago, for the Civil Justice Authority in England and Wales and CEDAR and a couple of others to intervene in the case, which the commentators are billing as heralding the end of Halsey's ban on making mediation compulsory. And it will be really fascinating to see the outcome of that case, because in my short history of mediation in the UK, we have gone from awareness and acceptance from the mid-90s to the cases in the early 2000s, the resolution of those cases in favour of encouragement but not compulsion in Halsey, the influence of Halsey over what is nearly 20 years, and now 20 years on, by the Churchill and Merthyr Tydfil case, we may find that Halsey will be set aside and that the squeamishness about making mediation compulsory will be removed in the UK. Looking historically at one or two other developments, we should not overlook the Singapore Convention. You heard a little about that yesterday from George Lim, and the Singapore Convention places mediation in an equivalence to arbitration for international commercial disputes. There are, although I'm sure I'm incorrect, but I have counted 19 Commonwealth signatories, including India, and in May of this year, the United Kingdom. the status and respect that the Singapore Convention gives to mediation is not to be underestimated. We've got a convention, fellow mediators. We surely can see that mediation has really developed and is now recognized and respected. The status that the convention gives to mediation represents an amazing transformation of the place of mediation in many justice systems. Indeed, at a meeting of the Commonwealth law ministers in Mauritius in November of last year, I was pleased to present a paper on the Singapore Convention, and the Commonwealth law ministers' policy is to encourage all their governments to sign the convention. They believe, you see, it contributes to trade and investment by having an accessible and understood system of resolving disputes in a way which can be enforced under the terms of the convention. Many countries have also accepted the need to legislate. And in Ireland, the part of the island of Ireland that is not Northern Ireland, there is a Mediation Act of 2017. And this imposes on lawyers an obligation to advise their clients about the availability of mediation as an option for their dispute. And of course, when you have an obligation to advise, the lawyers have to know something about what it is they're advising on. And so the lawyers need to understand in quite a deep way what the mediation process is, what might be the advantages and disadvantages of participating from their clients, what mediation style of mediator might favor the particular dispute. And all of those are questions that arise in a mature mediation justice system. In India, you will be aware of your mediation bill. I was reading about the acceptance, I believe, by your parliament of recommendations from a high-level committee. And indeed, some members of that committee might be present in this discussion now. And my reading of it suggests that the recommendation was not to make mediation compulsory before proceedings would be issued. I may be paraphrasing inaccurately, but for reasons that I hope to explain in a moment, I believe potentially that that has been an opportunity missed. I believe the tide is drifting towards mediation being obligatory. And I will return to that momentarily. In the UK, in England and Wales, in all parts, mediation is now used really routinely. For professional negligence cases, the insurers will simply refer to mediation. Many commercial disputes of huge value are successfully and frequently mediated. In family disputes and in disputes over wills and inheritances, mediation is ideal. In small business disputes, and some small businesses are actually not so small, but family-owned businesses where the founding business owner can't agree with the succession planning for the business among the family, mediation has a great part to play. But while we might be enthusiastic, there is still, in many jurisdictions where mediation is well embedded, a resistant legal profession. The culture of how we handle disputes leads us to the adversarial system with which we have all been trained and which we practice. And I wonder, culturally, how do we create a culture of problem-solving lawyers, of the focus, as Sir Geoffrey Voss has said, on resolution and not on the dispute. A move away from a process-heavy arrangement to a focus upon interests of parties. And this will, I believe, require a redefinition of what we refer to as justice. So my thoughts on the culture and future developments of mediation, very briefly, are that first we need to educate lawyers differently. Lawyers should be educated in the peacemaking way that Abraham Lincoln recommended. We should equip lawyers with negotiating skills. We should challenge the adversarial system and refer to it as simply one system among many. We should integrate litigation with mediation and the private decision-making that is arbitration. We should teach lawyers, although we of course do teach them, but we should continually remind lawyers that our duty is to the court and to the client. And our primary obligation is, as some of the cases I've referred to avoid litigation wherever it is possible. We should value the problem-solving lawyer. We need to redefine justice. At the Law Ministers' meeting in Mauritius, Professor Richard Susskind raised the interesting question, is a court a place or a service? And during COVID, we learned that access can be achieved remotely, that perfectly satisfactory resolution of matters can be achieved without having to wait around court corridors and maybe be disappointed that nothing much else was achieved during your day if the matter was adjourned. So accessing justice can mean accessing mediation, and accessing mediation is not a denial of an access to justice, because as you, I hope, know, and your clients who have enjoyed mediation will know, they get justice in a mediation. The clients feel that they have had their day in court. The formality of the process, the informality of the process, the conduct of the mediator as a neutral party chairing the talks effectively gives parties a sense that they have experienced a process akin to a justice process. So I believe that the definition of accessing justice will continue to evolve and will involve mediation. A really important part of culture is the ethical framework within mediators operate. Mediators must be taught about ethical standards in order to maintain trust and confidence in the process and in the mediators. We must do no harm. If matters do not resolve, the parties can continue into court and they will receive a decision. But the mediators must act always within an accepted ethical framework. In order for mediation to flourish, we need training. We need a cohort of trained mediators to be sufficient to meet an uptake in demand. And in that regard, the CLA will stand ready and willing to assist with training and capacity building in mediation where requested. I think the court's role will evolve. In many jurisdictions, mediation is court annexed in that the court will appoint mediators from a panel that they have also appointed. I tend to favor a more independent mediation profession where the parties are encouraged to seek a mediator from one of the many providers that are available, and the court proceedings would be stayed without any adverse implications of time limits. Many judges are interested in mediating cases. And I'm going to be slightly controversial to my judicial friends when I say I think judges should decide cases. I do not think they should mediate cases. I think there's plenty of pending cases that they should deal with and decide, and mediating a case takes them out of that case, then involves another judge to decide it if it has not been successfully resolved. And the attitude of the parties to a sitting judge acting as mediator, I think, skews the balance. The authority of the judge, the respect rightly afforded to a sitting judge, I think, alters the dynamic of a mediation. As for judges who are retired becoming mediators, I think they need to undergo training after their years of telling people what to do and deciding cases. Their skill set may not in every case be applicable to mediation. And again, I slightly worry about the power imbalance and the authority of the mediator, who might be more directive to the parties in reaching a solution. So we will watch with interest the evolving role of judges and courts. But finally, I wanted to mention compulsion and mandating mediation. My view has changed. I have been reading, as part of the preparation for this talk, many articles about jurisdictions such as Australia, where mediation is mandatory. There's no squeamishness about it. You just have to go and try and resolve your case before you access the court. It doesn't deny you access to the court. It doesn't compel you to agree something. It simply compels you to go through part of the process. In the same way as you need to issue a writ, or you need to issue an originating summons, and you pay money, and in England, very substantial money to issue a writ, then why should you not be told to go and meet with a mediator and try and resolve your matters before taking up court time? We know that most cases resolve, and we know that there is no drop-off in an agreement rate in jurisdictions where mediation has been made mandatory. The mandatory bit applies to undergoing the process. It does not apply to mandating that you have to agree something. And it certainly does not mean that having tried but not succeeded in reaching a resolution, that you are denied access to court. In my view, mediation should be turned to in a mandatory way to improve the quality of outcomes for parties with dispute. And I'm a little concerned that it is being touted as a way of reducing the pendency of cases. That should be a byproduct of using a quality system rather than the goal of using mediation as a means of reducing cases. However, I am very well aware that our friend Lord Dyson has a completely different perspective, as he expressed at the first mediation conference in Belfast. What he said was, there is a philosophical point to be made about mandating mediation. Is it just that a party who wishes to exercise his right to go to court be forced to sit down with the person he believes to have wronged him in order to find a compromise? It is not the role of the law to force compromise on people who do not want it by forcing them to engage in a mediation process. Parties who have a strong case and who seek vindication rather than compromise should not be denied their day in court. With this in mind, it is my strong view, said Lord Dyson, that the courts should not order compulsory mediation. Well, we will see in the case of Churchill and Merthyr Tydfil, when it comes to the Court of Appeal in the next few weeks, whether that palsy view remains. And with that, I thank you for your attention. I hope that that will stimulate some discussion, and I hope that that shows the evolution of mediation in a very short, approximately 30-year time window, and look forward to any of your observations and questions now. Thank you.
Thank you, Brian. We have been, initially, we have asked all the spectators, those who are participants, to give any questions so that that can be asked from you. I have received a few questions, and they are bilaterally, what I want to ask is whether the question which has been asked is whether the mediation should be statutorily mandatory, as you said it in a Halsey judgment, or it should be having a voluntary purpose. Possibly, Brian, I would request you, since you have got an experience of different statutory provisions of the different world, different parts of the country, different parts of the world. So therefore, would you give an idea and to tell the audience that whether the statutory requirement of putting mediation before going to litigation is a mandatory requirement, or it should be a voluntary?
I really have struggled with this question, Jitendra, because when mediation is taught and how it was taught to me and how I teach it in my training courses, I say mediation is voluntary. It is the voluntariness that makes it so successful. You have effectively got people who are there because they want to be there, and there because they want to resolve issues. But in my experience, that is too much. Oh, it's too homespun, it is too neat, it is too theoretically pretty to say that, because we know that most people actually don't necessarily want to be in mediation. They want to get their dispute resolved. If they're given the opportunity, they don't necessarily want to have to give evidence in court and to be cross-examined. They don't want the expense. They want to try and just get the case over. Therefore, in many cases, telling them that they have to go to a process that has a very high prospect of resolving matters and which will be undertaken by a fully trained mediator, I think we should just get over our squeamishness about voluntariness. And I think we should say the courts are often overwhelmed and expensive. Here is a system that works, and let's use it more frequently. Let's train mediators. Let's change and evolve our legal system to be problem-solving lawyers, which is a very, very fulfilling role to play as lawyer, if I might say. And as the Abraham Lincoln quotation said, there will still be business enough. So that's my response to that initial query, Jitendra.
Would it be a requirement, a statutory requirement that must go before litigation would be an option, or it should be still left to the parties? That could be an option, should be there.
What the UK have done is they have created court protocols and practice directions saying that the overriding objective is to avoid litigation where possible, that they encourage and provide information about mediation, and they have penalized parties who unreasonably refuse to mediate. But the courts have, because of Halsey, steered away from compelling parties to mediate and ordering a stay to allow a mediation to take place. And in that respect, the courts in the UK anyway seem to have the control over staying proceedings or encouraging parties to mediate. I think legislation can work perfectly effectively to require parties who wish to access a court to undergo a mediation process. And we should just normalize it as a step in having your dispute resolved. And it is for that reason that I wonder, has the Indian Parliament missed an opportunity to lead the way? Because it is such a leading role that India has played with the Nivaaran Summer School and with some of your wonderful mediators, that I just wonder whether legislatively that would have been another leadership role for India to have taken. And I would be very interested in comments made either now or after this session on the issue of why the legislative process for your mediation bill seemed to shy away from making mediation compulsory before accessing the court. I'm seeing some chat, and I can't speak and read at the same time, but I would love the opportunity to read the chat after the session.
I appreciate, Brian. In India, in few of the rules, there is a commercial court or the consumer court. The practices do says the statutory requirement that there must be an attempt to mediation. Only when an attempt to mediation is failed, then you will go to the litigation. So possibly let's wait for the bill and let it come, because by and large it has been recommendations from the committee, and we are still awaiting our mediation bill, which will give it a statutory provision. From the participants, I would request all participants to please send questions, because I have another question which I have received till now. Please, participants, please do send your questions in the chat box. I would like to share it with Brian and take this opportunity, whatever your queries are. Another thing which has been asked, Brian, is how far mediation is good in criminal cases? So,
yes, I think in many countries there are some attempts at bringing victims and offenders together to try and improve the understanding of both points of view, and that has resulted in very courageous victims of crime meeting with perpetrators and explaining the impact on them. With regard to whether the court should be involved in some sort of mediative plea bargaining, I hesitate about that. I think that there is scope for impropriety in justice being conducted informally by deal making. And my view is that where there are crimes committed, where the state intervenes and can impose punishment on people who are convicted of wrongdoing, that should be done openly and in court, and the capacity for mediation in reaching a criminal sanction, I think, is limited.
Thank you, Brian. I miss guest faculty Sushila. Acknowledge her presence. She has been a very active, and you will be participants. You will be hearing her in a day or two whenever her session. I acknowledge and I welcome her. Brian, there is another question which has come from Gayatri Kalia. She has said, can you share on the initiatives in the UK and elsewhere that encourage and balance public mediation services, say by the court and court private services?
Yes, if there is to be some form of compulsion and mandating parties to mediate, there needs, of course, to be a mediation system. You can't just say parties go to mediation and there are no mediators, or it takes you 6 months to get an appointment with a mediator, or the mediators are inexperienced or poorly trained, because that will simply diminish mediation and diminish its capacity to spread and develop and evolve into this new system of justice to which I have alluded. So what one does need to have a parallel track of training and capacity from mediation groups. And the debate, which is a live debate, is whether mediators should be court officials, or should they be private entities. Again, I have a reservation about court officials mediating. I do not think that they are sufficiently neutral to be properly effective as mediators. I think they are part of the system. There could be encouragement to reach agreement, which maybe some parties are hesitant about, and there needs to be safeguards built in if we are to develop, if you like, a public sector of mediators to which disputes will be referred. And with many local housing authorities or public bodies that provide services, they have built into their terms of reference that disputes will be referred to mediation, and they identify mediator providers who have a pool of mediators on their books and can appoint people from that pool. So my preference, although we're talking simply a personal view, my personal view is that we should have independent mediators and not so much public sector providing mediation, but we need to have an adequate system of training and an adequate capacity in numbers for mediation to prevent us simply shifting delay from the courts into the mediation process.
Thank you, Brian. I must acknowledge the presence of John Bessie. There's another guest faculty. Participants will be hearing hearing him tomorrow. And I acknowledge the presence of Peter Menard, the president of Commonwealth Lawyers Association. Thank you, Peter and John and Sushila, for spending your time in this session. Peter, Brian, I've got another question from Kavita and Solanki. She is an advocate from Bombay High Court. As in India, in commercial mediation, it is mandatory to participants to go for mediation. First, is it the same as well in the other jurisdictions also? Kindly enlighten on the same.
I thank Kavita for that. Yes. And I recall visiting with Santan, the Bombay High Court. So I note that is where you practice. In the UK, it is not mandatory to go to mediation in commercial matters, but it is hugely common. The cost of conducting commercial litigation is very prohibitive, and parties are often experience mediation because they are presented with it by their advisors, because the legal profession over the last 30 years has greatly become aware of mediation as being something to be used in their clients' interests. So it is not mandated to go, but as we have heard, if you refuse to go to mediation when it is offered, then you run the risk of not recovering your costs, even if you have been successful. And it does seem to me that we have a way to go before overwhelmingly the view in the UK will be in favor of mandating mediation. And I simply reiterate what Lord Dyson said. Parties who have a strong case and who seek vindication rather than compromise should not be denied their day in court. And there will be some commercial parties who simply want their day in court and will resist being compelled to undertake a mediation process. But the justice system, which we all pay for through our taxes, needs to be responsive to changing trends. And just because you have a right to go to court doesn't mean that every case must go to court. And as we know, most cases settle or resolve in some way, and that the experience of thousands and hundreds of thousands of litigants is not an experience of their resolution in court, but it is more the experience of it being resolved perhaps in a court corridor or outside a court. But there is no mandating of commercial matters to go to mediation yet in the UK.
Thank you, Brian. There is another question by Sangeeta Melutra. She is asking about this. There is a key amendments in the mediation bill in India, 2021, including removal of a provision that made pre-litigation mediation mandatory before parties could file a suit, regardless of the existence of mediation agreement, were cleared by the parties. He's saying pre-litigation mediation, whether it should be made mandatory. We have been asking, having this few questions on that aspect. Would you again say something on that?
Mediation, because it is not a statutorily provided for process, it is a feature of contract between the parties. People commonly write into their contracts, if we have a dispute, we agree to go to mediation. The mediation will be provided by the ADR group, or in my case, the Law Society Mediation Service in Northern Ireland. In common contracts, such as ordinary house conveyancing contracts, there is a provision that if there's a dispute, matters would be referred to mediation. So mediation is said to be a creature of contract. It did seem to me peculiar, if I read the reports of the mediation bill in India correctly, that there wasn't an obligation, or that people who had made a contract to mediate were not by statute mandated to fulfill their contractual commitment to mediate. And I think that Sangeeta's question mentions that it's not going to be made mandatory to conduct pre-litigation mediation, even if there is a mediation agreement between the parties. And so I again think that's quite a retreat from mandating mediation and quite an emphasis on the voluntariness of the process. And if that's the direction that the Indian mediation leaders are going, that's just very interesting to me, that clearly some thought has been given to this question of mandating and voluntariness, and you seem to be coming down more on the voluntariness side.
There is another question by Nishtha Singhal. She said, sir, you mentioned about following the importance of following the ethical principle framework in mediation. Could you share the most important ethical principle, the ethical principles which is mandatory?
Mediation is said to be a confidential process, and there are some exceptions to keeping what is said in mediation confidential, and there are some very good reasons why it should be kept confidential. So I would say that preserving the confidentiality of the process is something that mediators need to understand. I was recently involved in a mediation involving a church minister and his congregation. And it was really very sensitive. And the confidentiality had to extend even to whether or not a mediation was taking place. And so I think that mediators need to understand what is confidential. They need to understand what they learn from discussions privately with one party, what they can share with the other party. And they need to be alive to their role as being neutral. And certainly my approach to mediation is very much of a facilitative model. And you need to be alert to when you are telling parties what to do, as opposed to presenting options or possibilities for consideration by the parties. So understanding the role of the mediator to maintain trust and confidence, to maintain confidentiality, and to know what information can or cannot be shared are all very key parts of how to conduct appropriately your role as mediator.
There is another question by Dr. Rahul Shrivastava. He says Article 6 of the European Convention on Human Rights and compulsory mediation. How do you propose to reduce justice? How can we ensure publicness in justice? Publicness in justice, and there is a compulsory mediation by European Convention.
This is another big debate, friends. It is said that having a case decided in open court and having the doctrine of precedent that common law jurisdictions have allow litigants and other lawyers to access what the law is and to understand the reasoning and thinking of the judges who decide the cases. If cases are decided or resolved in private, then what impact does that have on the development of jurisprudence and the benefiting of other parties who may have cases with similar facts? So there is an issue, if I've understood the question correctly, there is an issue about the private nature of mediation as opposed to the public availability of access to decision-making and justice being seen to be done. Indeed, in some mediations I have undertaken with public authorities, they resist signing up to some of the confidentiality arrangements relating to if a settlement is achieved. One party I found might want to keep the terms confidential. They might even argue that it is easier for a public authority to agree something generous by way of resolution if it is kept confidential. But we find that most local authorities say that they have to be public in their accounting, and if they have had to resolve a matter on a more generous scale than perhaps other cases, they just have to be public in their accounting about that. So public decision-making, public accountability of reaching agreement as against private decision-making is a very interesting debate. And where you have two private parties, it might be easier for them, albeit if they are publicly listed, there is a certain transparency expected from them. But when you're dealing with public entities, health trusts, local authorities, and the like, then you will, I think, come across this dynamic of a tension between resolving something in private and yet fulfilling their public accountability obligations. With regard to Article 6 and your right to a trial, the the case of Alabi simply concluded that requiring parties to mediate did not interfere with your right to a trial. The Civil Justice Report of July 2021 concluded that mandating mediation did not interfere with your Article 6 rights. Mandating mediation, as I said, does not mean requiring you to reach an agreement. It simply requires you to take part in a process to explore if a resolution under the expert guidance of a mediator can be achieved.
Thank you, Brian. There are a lot of questions are coming because of paucity of time, I'm taking up the last question. This will be the last question. Any other participants, any other questions which you have mentioned, we'll try to put it in with Brian, and we'll try to send it by mail if it is there. But we are taking up in this open session only. This is the last question which I'm taking. This is from Vijay Kumar. He has asked, sir, how to register mediation agreement in India? Is it beneficial to register the mediation agreement even if it fails?
If an agreement is made in mediation, then that is an agreement that's fully enforceable as a contract. It can be made a rule of court if the parties agree, and the mediation agreement under the Singapore Convention, if made between two, if it's an international commercial dispute with ratifying countries involved, then that agreement can be enforced in the same way as a court judgment can be mutually enforced and recognized, or an arbitration award can be enforced. One question is, what did the parties agree? And of course, that's where the agreement concluded at a mediation needs to be carefully and comprehensively written so that it is complete and clear and does not contain any ambiguities that mean there's a dispute about what was agreed. And that has certainly happened in many jurisdictions. And one of your speakers later in Nivaaran, Justice Kokharam, might mention some interesting cases in which he was involving a dispute over what had or had not been agreed. As to registering agreements, I think the only circumstance in which that can be done is if the parties wish to make an agreement a rule of court. What went on in a mediation is confidential and private to the parties, and if no agreement was reached, in my view, nothing more can be said about the process. And because the process has been conducted on a without prejudice basis, and a mediation contract between the parties and the mediator will say that the mediation is to be conducted on a without prejudice basis, then nothing said during the mediation should be referenced. And we did have in Belfast a very awkward situation where the senior family law judge was asking family law mediators what happened in the mediation. Was it the father or the mother who was the obstacle to reaching agreement? And even went so far as to suggest that there should be a report filed. And that led to quite a hoo-ha. And mercifully, the mediation community in my jurisdiction were able to persuade that the value of confidentiality in mediation and the fact that no agreement was reached should not be looked behind by the court to see if someone's behavior was or was not stubborn or difficult. They just should be told, we have attempted mediation and unfortunately no resolution was achieved, and the matter now comes before the court for decision.
Thank you, Brian. I just add to it, whenever, in my experience, whenever a mediation is not successful, we just record a mid-process that the settlement did not arrive at this stage, because mediation never fails. I have come across cases where a mediation at one stage, it was not successful, but later on it came to know that it became successful. So we always say, unable to arrive amicable settlement at this stage. So mediation never fails. The parties have not arrived yet. Thank you, Brian. Thank you for giving us such a daring lecture. Even in your holidays, you have been able to give us time. So we are grateful to you, and particularly to your partner who has allowed you to spend so much of time from take out from your holidays. So we are grateful to her, so that you were able to, we are thankful to her. The insight which you gave today about the mediators, that they are the peacemakers, they are the problem solvers. The mediators can always be resolved in resolving a dispute, can always be a problem solver. They can help in arriving at a solution which endears peace. Possibly in coming session, you will come to know about the peace jurisprudence, which is Justice Vashisht Kokaram will be saying, because it is whenever there is a mediation settlement arrives at, the peace prevails. And whenever there is a peace prevails, there is a prosperity and happiness. And ultimately, the aim of a society and social circles is to have an happiness and to all around. And mediators have a role to play in that. Thank you, Brian, for that. I just put our session end today, and I will remind for all participants for tomorrow's lecture. Tomorrow's session is of John Bessie. He's a president of Jamaica Bar Association, and his topic will be an overview of conflict and the style of conflict management, resolution, and transformation. Thank you very much. Thank you very much, participants, for being so vigilant and participating and asking questions. Be vigilant. That shows how interested you are in the topic. Thank you so much. Thank you very much. Thank you.
Thank you. Thank you. Bye-bye.
Bye.
Thanks, Brian.
Thanks, Santan. Bye.
Thanks, Santan. Thanks, Santan. Bye. Thanks, Brian.
Bye. I'm off to the pool now. Bye-bye.